we are going to, in many ways, step out of the courtroom, although I will say that all of the panelists here know a great deal about what happened in the courtroom and were, in fact, present in the court for both days of the hearings. But what I really want to do is go into something that's strictly hypothetical. And I'm not going to ask the panelists to give their predictions, to make predictions about what might happen, or what the court's outcome will be. But I want them to come up with hypotheticals, hypothetical scenarios. If this rule is remanded, if these other two rules are upheld, then what happens? What are those implications? What are the dominoes? What one rule might fall if other rules fall? What is the precedent for other greenhouse gas regulations for something else on the books? What is it actually going to mean for industry? What will it actually mean for reducing emissions for the nation's greenhouse gas emissions? What will it mean for the schedule for when regulations come out? These are some of the sort of questions. Again, it will be strictly hypothetical, and I will note that everybody here will be speaking for themselves. Even though some of them were representing clients before the court or are parties on the court today, they will just be speaking for themselves. Now, of course, and I should say, I myself am not a lawyer, and I don't, therefore, feel under the same constraints as they do to make predictions or not make predictions. So based on what I heard from this morning's panel, I'll make a prediction. This morning's panel, the first panel, they said, well, the first day went very well for EPA. The first day they covered the endangerment rule and the tailpipe rule. So I'm going to predict that those two rules, by and large, are going to, EPA will be in pretty good shape on those. EPA will probably, by and large, escape without too many changes to those rules. But the second day really didn't go so well for EPA. There were a lot of questions from the judges on the tailoring rule, on the timing rule, and I'm going to predict that those rules are going to find some problems, maybe not be completely overturned, but will perhaps have some be remanded to the agency with some corrections necessary. Now, I will also say that if you're taking your predictions from a non-lawyer who's not an expert in the Clean Air Act, your judgment is probably questionable. But let's see. It's I guess the other thing I want to do next is say how we're going to go through it and how we're going to do this panel. So we've got about an hour and 15 minutes or maybe a little bit more. And we're going to go through the rules in the same order that the court went through them. So basically, first the two rules that were done on the first day, the endangerment finding, endangerment rule, and the tailpipe rule, and then second, timing and tailoring. And I've asked each one of our panelists to come up with a hypothetical situation or to discuss the implications for one of those rules. And I'll go through it in a moment and just say which panelist has been given which rule, with the exception that timing and tailoring really are quite hard to separate, so two people are going to do those. But without further ado, I'd like to now introduce our panelists, who are a very distinguished group. Dina Kruger, immediately to my right, is a principal with Kruger Environmental Strategies, and from 2004 to 2011, she was director of the Climate Change Division at US EPA. To her right is Peter Zalzal, staff attorney for Climate and Air at Environmental Defense Fund. EDF, of course, was one of the interveners yesterday. Peter is an intervener for EDF on all of the briefs. Let's see, to Peter's right is Allison Wood, who is a partner at Hunton and Williams. And Allison also was a petitioner on all the challenges to the greenhouse gas rules over the last 2 days. and she represents the Utility Air Regulatory Group. And then finally, Kyle Danish, who's a partner at Van Ness Feldman and is a very well-known, recognized expert on climate and carbon policy. So we're going to start with the endangerment finding, and I'm going to ask Dina to, well, let's see. First, we're going to divide up into 10-minute segments or thereabouts, 10 minutes or so on each rule, with the last two sort of combined together. And Dina is going to take the first 5 minutes or so of that and go over a set of implications and scenarios, and then we'll open up for discussion before turning to a set of implications and scenarios on the next rule. Dina, since you, as head of the Climate Change Division at EPA, actually developed, you actually led the team that wrote the endangerment finding. So I think it is appropriate that we start with you, we start on the endangerment finding, and Dina, please tell me what implications and scenarios can you come up with around that rule?
Thanks very much. I'm really, people hear me? Is this working? Okay, I'm really delighted to be here today. I'm also very happy that you asked the question about the lawyers versus non-lawyers in the room. I'm the only person on this panel who is not a lawyer, so I'm going to try to avoid using legal jargon that I don't really understand. When I was at EPA immediately after the Supreme Court decision, the Bush administration at that time did engage very seriously in a process to respond to the court. And so within a few weeks, we were in with our political leadership talking about what needed to be done, and clearly what needed to be done was an endangerment finding and the follow-on vehicle rules if that finding was positive. Prior to that, I actually was 22 years at EPA working climate and energy issues, and prior to that, the people that did climate didn't do regulation for obvious reasons. So I actually asked at that meeting, I asked the lawyers at that meeting, hey, can you give me some samples of previous endangerment findings for other pollutants that we could maybe use as a model? And they said yes. And what they gave us were very brief, very cursory endangerment findings that would be like a column in a Federal Register notice. And if you've looked at EPA's endangerment finding for climate, you know that it is extremely lengthy and detailed. This was an endangerment finding unlike any other. And I think that's important because it's there are a lot of issues around it. What I wanted to do this morning was talk about a couple of things following up on the wonderful summation of the arguments on this that Tracy Triplett provided. First, I think it's important to recognize in this, and this can get confused, gets confused sometimes. As she mentioned, this is actually two separate findings, kind of collectively called the endangerment finding. The first and largest part of the work was related to whether or not greenhouse gas pollution can be reasonably anticipated to endanger health and welfare. And so that was a very extensive science-based exercise that EPA went through. And the second finding was related to cause and contribution, because in order to then go forward with regulation under Section 202A of the Title II, the Motor Vehicles Rule, you need to determine that motor vehicles emit pollutants that cause or contribute to the endangerment finding, and to the endangerment. And this is important because it's something that kind of was getting lost in this 4-gas, 6-gas discussion when the court was talking about it, and it has an important implication for what might happen if the court were to decide that they don't feel comfortable with the 6-gas definition of air pollutant. They think it should have been a 4-gas definition of air pollutant. In my view, that is a narrow question related to the definition of air pollutant and would be dealt with in the context of the cause and contribution finding, if that were sent back to EPA. That the definition of the air pollution that endangers is different. That's the collective, the concentration of these well-mixed, these 6 well-mixed greenhouse gases in the atmosphere that are causing the global warming that is endangering. And that was not, there was not an argument about 6 gases versus 4 gases in the actual endangerment finding itself. It was in the cause and contribute, and that was where Judge Santel, or Justice Santel, was having all those issues. So I think if, and it's hard to know, as people were saying on the previous panel, it's hard to know where the other 2 justices are going to come down and whether this will actually end up coming back to EPA. My own sense is that if it does come back to EPA, I would not expect that this would be accompanied by a stay of the entire endangerment finding and an unraveling of the entire of the vehicle rule and everything that followed it. I think it would be sent back, and EPA would be told to take another look and potentially have to redefine the pollutant in a different way. And the 4 gases are the ones that are emitted by vehicles that would go forward. It wouldn't affect the tailpipe rule. And at this point, it's not clear that it would really have that significant of an impact on the tailoring rule either. There haven't been that many permits issued, and I haven't gone back to check recently, but I'm not sure that any of them have been issued for these 2 other gases. So, so the consequences of that might not be, so adverse. The second issue, I guess I'll talk about, Tracy had mentioned a number of, some of the sort of more scientific issues, how the court can decide, how do they know whether or not, when they're supposed to give deference to EPA on these things, the non-scientific factors. Here I think the nature of the record that EPA has developed in support of the finding is hopefully where they'll look. Because most of the issues that were raised by the petitioners and continued to come up had been responded to in the underlying scientific record, and that was part of what EPA was arguing in its brief. So I think that's, the court is obviously, and they were clear, they're not going to decide climate science for themselves. It's the record that they look to. And then I think the third point I'll make, I'll sort of talk about, relates to the reconsideration, the discussion around the reconsideration of the endangerment finding and EPA's denial of that reconsideration, and essentially, immediately following the completion of the issuance of the finding, a number of petitions came in. It was, I want to say it was on the order of like 800 more pages of scientific information and all of the emails from that had come out from the climate research unit in the UK, and a lot of additional literature and things that they wanted us to take a look at. So the staff at EPA went through in detail all of that and denied that petition with a very lengthy record. And I think what the petitioners were primarily arguing was, that EPA had misunderstood the determination they were supposed to make here, and that as long as the petitioners were raising sort of a reasonable argument, that we should have actually granted the reconsideration and then put something like what we had done for the denial out for notice and comment. Here again, I think it would be unlikely that that if the court decided that there was this procedural error and EPA should have put the finding out for notice and comment, that they would at the same time decide to stay the endangerment finding. EPA reconsiders regulations all the time without staying them, and the threshold for stay is pretty high. So my sense is that they would have to go through, in that case they would have to go back and probably put this out for notice and comment, and the impact of that would be a lot of work for the people at EPA that have to go through that, because we had at the time that we proposed the endangerment finding in 2009, we set an agency record 380,000 public comments. That record has since been broken by just about every rule that followed it. But I would anticipate, one would anticipate that the agency would get that kind of response and more so again, and just the amount of sort of government resources expended to managing the response to that kind of comment would be So it would be pretty difficult. So I hope for my former colleagues' sake that they don't have to go down that road. But again, I don't think that it would fundamentally lead to a change in the finding that would impact the rules that followed. And I'll stop there.
So if I could summarize in the lay terms for both the non-lawyer and the non-person who didn't spend 20 years working at EPA, essentially, it's unlikely that very much of anything is going to come out of the challenges to the endangerment finding in terms of their impacting anything else, any of the other regulations or anything else down the road. There probably won't be a stay. EPA might have to redefine some pollutants, but that probably doesn't make much difference to anything very much. EPA might have to reconsider, do a whole lot of work reconsidering something that they already considered and reconsidered with hundreds and hundreds of pages. But that, other than making more work for the agency and costing taxpayers more money, probably won't have too much different on any of the regulations, any of the steps coming down the way. Is that, turning to the other panelists, is that the sense that the rest of you get, or does, I don't want to spend too much time on this before moving on to the next section, but does anybody disagree with that?
David, I think that there's one thing that I just want to clarify. I don't disagree with that. But just for the non-lawyers in the room, I think this is important, not just for the endangerment finding rule, but for the other rules, a thing to understand about what the court can do. If the petitioners were to win on an issue or win on a rule, the court has two choices before it. One is it can just remand it back to the agency and say, fix it, but in the meantime, it leaves the rule in place. And so that is where you're saying that, there wouldn't be a big impact. So for example, they could say on the reconsideration point, we do think EPA, you should have accepted public comments on this reconsideration issue. You have to go back and do that, but it would have no impact because they wouldn't actually vacate the endangerment findings. So in other words, everything stays the same, but EPA goes back and does a rulemaking and reconsiders it. As opposed to the other option the court has, which is to vacate a rule. Vacating a rule means it goes away as though it was never put in place. And so if a rule is vacated, you have much more draconian outcome, particularly here if you were talking about the endangerment finding. If the court were to somehow find that something was wrong in that rulemaking and vacate it, everything else that follows it falls because it is the predicate for the auto rule. You can't have the auto rule without the endangerment finding. And if you don't have the auto rule, you have no need for the tailoring and timing rules. So do I think that, there's a chance that the court is going to vacate the endangerment finding? No, I don't. I don't think anyone in this room realistically thinks that's a possibility. So I do agree with you, but I do think it's important to sort of understand as we go forward and we talk about these other rules, that distinction about what it is the court can do.
So the court is unlikely to vacate endangerment. They might have some changes, but probably won't have very much effect on anything else in terms of slowing everything else down. And let's now turn to Peter. Again, Peter was an intervener for EDF on all the briefs. EDF, Environmental Defense Fund, was one of the original petitioners, of course, in the landmark 2007 Supreme Court case, Massachusetts versus EPA. And I'll note that EDF has also been very involved, not just in Washington and at the federal level, but also at the state level in California on regulating emissions from motor vehicles. So, Peter, let's turn to the tailpipe rule. But I wonder if you could actually, before getting too much into the implications, what is really at stake here? I mean, what difference does this rule actually make? How is it different from the CAFE rules? If this is overturned, what's the difference on greenhouse gases and who's going to be impacted by it?
So thank you, David, and again, thank you to everyone for the opportunity to be here today. To answer that question, it's a significant impact, and to look at the rule itself, the rule reduces greenhouse gases over the life of the vehicles regulated by 960 million metric tons of CO2 equivalent. saves consumers $3,000 in a 2016 model year vehicle, and reduces our oil imports by 1.8 billion barrels, per day. So the impacts are significant, and I think your specific question, are the impacts different than those achieved by the CAFE rules? They are. They're about 40% greater, as the earlier panelists mentioned. EPA is able to regulate emissions from air conditioners. The CAFE rules aren't able to do that. And to step back even a little bit further, EPA's regulations under the Clean Air Act are intended to protect human health and the environment. There's a greater degree of flexibility there. The CAFE standards, NHTSA's authority under the CAFE standards is quite different. It's intended to promote fuel economy. So there are different statutory purposes there. The court discussed that in Massachusetts versus EPA. And so, I think the importance of these specific vehicle rules can't be overstated. They're quite significant. I'd actually like to say a few things, kind of building on your endangerment question as well. I think we talked about what are the likely outcomes for the endangerment finding, and sort of how do those impact, specifically what the court may do with respect to that finding. But I think it's also important to think through, why is the endangerment finding so important? Certainly it's an important predicate for the vehicle rule. But it's also quite important for any sort of emission standards that the agency may promulgate under Section 202 of the Clean Air Act. There are additional standards that have been recently finalized and are also in the proposed stage that also make quite significant reductions. So the agency has promulgated the first ever standards for medium and heavy duty vehicles, which achieve quite significant reductions and fuel cost savings. The agency has also just proposed a second phase of light-duty vehicle rules, and those rules build on the Phase 1 rules. They cover vehicles from model year 2017 to 2025, again, significant fuel cost savings and really very significant greenhouse gas reductions. So I wanted to just add that as, I think an important implication of our discussion about the endangerment finding.
Let's see, before we move on to the next sections, so thanks very much, Peter. But let's get a little bit more into detail on the tailpipe rule. So, and actually, Kyle, I'm going to ask you a question. The automakers, you have a lot of experience with a lot of different industries and covering very broadly. Where do the automakers come down on this?
This was alluded to in the first panel, I think, by Tim Webster, but a notable aspect of the argument that many people noticed was that the automakers intervened on the side of the government in the tailpipe rule argument, and why is that? And this is a good way to think about some of the implications in, I think, the unlikely event that the tailpipe rule would be invalidated in some way. What implications for the automakers? What caused them to come in on the side of the government? And the background here is that the Clean Air Act generally preempts states from setting emission standards for new motor vehicles. There is, however, a long-standing waiver process for the state of California that allows California, under certain circumstances, to establish its own standards for new motor vehicles. And then other states, in that event, may adopt either the federal standard or the California standard. So part of the long lead-up to the oral argument from the previous 2 days is that California did move forward with its own greenhouse gas emission standard, and this EPA took steps to grant it the waiver that it needed to enforce those standards. And a number of other states indicated that they too would adopt the California standard. That was one thread here. The second thread was that the Energy Independence and Security Act of 2007 directed NHTSA to develop new fuel economy standards, something that had been essentially in suspension for quite a long time. And then the Massachusetts v. EPA decision effectively directed EPA to engage in the endangerment finding. So what does this look like from the perspective of automakers? Well, the potential really for a whole host of different standards that would essentially apply to the same thing and lead to the need to create a whole bunch of different vehicles. They would be facing a stringent California standard that would be adopted by other states. And by the way, when another state adopts the California number, that may have very different implications for what vehicles you send into that state, right? Because some states you're sending in a lot of trucks and you really can't comply with the California standard there. So you have really a mess of state standards, at least in the view of the auto industry. You have now the fuel economy standard coming down from NHTSA, and you have a likely EPA standard. So this gave rise to this sort of landmark negotiation involving the White House and the EPA and the NHTSA and California and other states and the auto industry to come up with essentially a coordinated joint approach, at least joint as between NHTSA and EPA, and an understanding by California that compliance with this joint federal standard would constitute compliance with its standard as well. So this long story is what brought the auto industry in to intervene on the side of the government to protect this arrangement. And so even, for instance, when you heard, I think a question was asked to the auto industry advocate whether they would be okay with an approach that would in which EPA would only regulate CFCs from air conditioners and leave carbon dioxide to be taken care of by the fuel economy standards. Wasn't interested in that, even though it would ostensibly provide relief in this sort of narrow context of federal regulation. I think they were assuming it would give rise then to California's ability to enforce its own more stringent standard. So while it does seem, I think, it didn't seem like the court was very interested in the sort of decisions that would knock out the tailpipe rule. It's important to consider the implications that were in sight from that sort of decision.
So the first panel actually referred to the attack on the tailpipe rule as perhaps a bit of a shell game. And it sounds like with basically the automakers they need, in fact, the regulations to stay in place in order to protect them from the horrible draconian states who might otherwise go off and do all sorts of things on their own. So really there's not very much of a challenge to the tailpipe rule here. I mean, Peter's giving me evil eyes for calling this stage draconian, but there's not much of a challenge to the tailpipe here. I'll give if anyone really wants to disagree with me on that before we move on to the next segment, go ahead.
So I don't want to disagree, so I would disagree about the deployment comment. But I don't want to otherwise disagree, but I do want to underscore something Kyle said, just about the importance of these regulations for providing certainty for the auto industry. So in the stay portion of this litigation, automakers filed affidavits under seal with the court stating how economically harmful rolling back these regulations would be. So I think when we're thinking about impacts of the regulations, and I agree it's not a likely scenario, that we're going to get the court to vacate these regulations, but there are environmental, economic, public health impacts, but also impacts to the regulated industry here. So just wanted to underscore that.
And I'll just underscore quickly that Tim Webster did make clear that most of the petitioners were very clear that they weren't attacking the auto rules per se. What they were upset about is the interpretation that the auto rules are what triggered the PSD and Title V requirements for stationary sources. So while there was an attack lodged against the auto rule, you did see where the petitioners were somewhat sympathetic to the autos, wanting the rules to stay in place. But we're also arguing, there were really, I would say, kind of two core arguments that petitioners made. One was the EPA had discretion over the timing of those rules, that it could have waited to do it later rather than lead to the absurd results that happened from regulating greenhouse gases that then lead you to get the tailoring rule. And then the other argument was, Peter's mentioned that because of the regulations on air conditioners, you get 40% more reduction in greenhouse gases that you don't get from just the NHTSA fuel economy standards. And petitioners made 2 points about that. One, that you could get the, you could either just regulate just the air conditioners, if that was your concern, and then you would not be regulating carbon dioxide, which is really where the big problem comes in and the absurd results happen with PSD. Or alternatively, what they pointed out was that even though you have 40% greater reductions in greenhouse gases, if you look at the projections from the regulations that NHTSA has and that EPA has, it shows pretty much identical results. So in other words, the environmental benefit that you're getting from this additional 40% isn't resulting in any greater benefit.
Thanks very much, Allison. With that, let's move on to where the real heart of the matter, the timing and tailoring rule. We're now on to day 2 of the oral arguments. I'm going to ask both Kyle and Allison. We're going to spend the most time on this section. They're going to tag team on this. Originally, we were going to have one do timing and one do implications of tailoring, but you really just can't separate them very well. So Kyle and Allison, I'm not sure which one of you wants to start. You both know these things inside and out. I'll leave it up to you.
I am going to begin, and I'm also wrapped up in the timing and the tailoring is also the historical interpretation case that we were talking about. So really, everything that was argued yesterday, the day 2 arguments. And what Kyle and I decided might make sense in terms of dividing up how to introduce the topic is I'm going to talk very briefly about different ways I think, the court could rule. Some of them I think, maybe are possible. Some I might not think are very probable at all. But just to sort of lay out, these are options that would be before the court. And then Kyle is going to take it from there and I think give a little more, well, what would that mean and, how probable is it that the court would rule that way?
And I would like to say on Allison's behalf too, I would say that this is the least, this portion of the panel involves the least predictive, impact, I think. Is the hardest area to do any sort of speculation. So I would say, I'd ask you to take our comments as very much in this sort of hypothetical mode.
Yes, these are all hypotheticals. I would 100% agree with that. And like I said, just because I lay out an option doesn't mean I think it will or will not happen. So the first possibility, and for the non-lawyers in the room, there was some talk earlier about Chevron Step 1 and Chevron Step 2, and I'm going to just take a minute to sort of explain what that is, because that sort of sets up the framework for where we can go. When a court is looking at an agency's regulation, it looks to see whether it's been authorized by a statute. Here the statute is the Clean Air Act. And under Chevron Step 1, it looks to see if the language of the Clean Air Act is clear, then that's the end of the analysis. That's been what, here EPA would have to do. If the language of the statute isn't clear, if there's some ambiguity there, then EPA is allowed to interpret the language, and then under the Chevron Step 2 test, it only needs to be reasonable. So very quickly, there was one Chevron Step 1 argument made, and it was the argument that was really made by Texas, and that Bill Cobb was talking about earlier, and that was that because 100 and 250 tons is written straight into the statute, that's the end of the analysis. That's the level at which EPA must regulate. As was discussed, there was a lot of skepticism from the court as to whether Texas can even bring that claim, whether it had standing to bring the claim. And what standing is for the non-lawyers is to be able to bring a claim in federal court, you have to show that that what you're challenging harmed you, and that a decision by the court in your favor will remedy that harm. And the problem that Texas had was on this second point. Okay, they're saying that they're harmed because they have to do PSD regulation. But if the court had gone their way and said you have to do it at 100 or 250 tons, they were worse off, not better off. And so that was really the stumbling block to that claim even going forward. But assuming for the sake of argument that Texas could get over that standing hurdle, and the court would then say, yes, you're right, the statute's very clear, 100, 250 tons. That would be one option. So now suddenly you're in a world where you're supposed to regulate greenhouse gases under the PSD program at 100 or 250 tons, depending on the type of source. So that's one possibility. The second realm of possibilities is no, the statute's not clear. Now we're in Chevron step 2, and so we're looking at, was EPA's interpretation here reasonable? And this was where the court, I think, really seemed to focus yesterday, which was, is it reasonable to pick an interpretation that you're saying leads to absurd results? Petitioners have set forth, 3 different ways they say you could have interpreted it that would not have led to those absurd results. And the 3 arguments petitioners made were, first, you could have interpreted PSD pollutants just to not include greenhouse gases. And so if that were then the interpretation, you would have no PSD program for greenhouse gases. The second interpretation that was put forward was the one that said, and this goes to the historical interpretation, no, you only can do PSD for greenhouse gases if you're talking about a source that already had to get a PSD permit because it was subject to PSD for a criteria air pollutant. And this really would put you in what was step 1 of the tailoring rule, where you only, that was the result of that argument if you were to win. Then there was an argument made that EPA needed to do a rulemaking under Section 166 of the Clean Air Act. This was not argued yesterday, it was just submitted on the briefs. But that would end up leading to, send it back for a rulemaking. So you have these 3 interpretations that the petitioner set forth. So it seems to me the court, if it's going down this road, it could say either EPA's interpretation was reasonable in the tailoring rule, or it could say, no, we think you needed to adopt an interpretation that did not lead to absurd results. So, but then does the court just send it back to EPA to examine those interpretations? Or does the court look at these alternatives that were posited by petitioners and weigh in on whether it thinks they're good or bad? Unknown whether the court would do that, and that would obviously have an impact too. And then in terms of when Kyle is discussing these things, does it vacate the tailoring rule? Does it remand it? That will also affect whether or not, how PSD permitting goes forward if there were a victory for petitioners. And with that, set up.
Great, thank you. Okay. Well, I wanted to talk a little bit about implications, building off of Allison's sort of view of what the court could do in the short term, sort of the form of its decision here, and think about some of the implications that flow from those decisions. And I think it's helpful to separate these implications into 2 categories. One is implications generally for administrative law, or also the Clean Air Act. And then the second category is implications for climate policy or greenhouse gas regulation. It seems to me that if the courts, so in the first category, implications for administrative law, implications for the Clean Air Act, first with an administrative law one, it seems to me if the court's decision relies on the view that the agency has to in some way revisit its interpretation of the PSD provisions on account of grounds arising after. This was talked about, I think, very effectively in the first panel. A very key argument that got a lot of time yesterday is that what EPA said, look, we decided this 30 years ago. The petitioners said, look, grounds have come up since then that merit revisiting this in some way. This is a very central area of administrative law and of EPA, in particular implementing the Clean Air Act, because there are many sort of long-standing decisions out there. The Clean Air Act itself hasn't been amended since 1990. So a lot of the EPA and other agencies carrying out regulatory actions rely on fairly settled regulatory interpretations. So how the court looks at the question of when new circumstances can trigger the requirement to revisit an interpretation is actually a very important one, definitely for the Clean Air Act, more broadly for administrative law. And in particular, when you look at the effort of this agency in the context of the Clean Air Act to apply a statute that hasn't been amended since 1990 to a whole bunch of sort of difficult new circumstances like greenhouse gases, like regional air pollution in the context of the cross-state air pollution rule. This is a big area. So I'm very interested to see how the court will grapple with that and what sort of implications may flow from that. In a related way, as mentioned also in the first panel, a key part of whether the EPA's interpretation of this triggering effect was somehow resolved by the Alabama Power case, which is a very seminal case in the Clean Air Act, interpreted much of what is in the 1978 Clean Air Act. It's been relied on very much by the agency, again, in the absence of new action by the Congress since 1990. If the court finds that the Alabama Power decision did not resolve this particular area, well, that might open the door to a lot of other things that we thought Alabama Power did resolve, but turn out to be considered by the court just to be sort of what's called dicta, just sort of not something on point in the Alabama Power case, but just their sort of roving commentary on the statute. So that's another thing to watch in the area of sort of the Clean Air Act administrative law generally. The third area that I would focus in this first category is very Clean Air Act specific. If the court's decision essentially takes the form of or leads to the agency, it leads to an interpretation of the PSD provisions that say these provisions really only apply to emissions regulated under national ambient air quality standards, i.e. not greenhouse gases. Well, that's a sort of an interesting outcome too for people working in the Clean Air Act. There are permits that have been required and issued under the PSD program that do address non-NAAQS pollutants, and it would be interesting to see how the court's decision is framed and whether those, we talked a little bit on the phone, couldn't think how many permits would be affected, permits issued solely on account of non-NAAQS pollutants. I mean, are there hydrogen sulfide only pollutants out there? I don't really know. So that may be something to watch as well. Moving from there, the first category to the second category of sort of climate policy. So what are a couple implications that flow here? Well, if the court's decision is really confined to just the sort of issues that were raised by Allison, it doesn't reach the motor vehicle rule and the endangerment finding, well then the motor vehicle rule stands, and that's obviously an important pillar of EPA's climate policy for all the reasons that Peter said. This decision, if it's based on an interpretation of the PSD provisions, et cetera, in the Clean Air, doesn't affect the reporting program, right? The emissions reporting program that many companies are contending with right now and collecting a lot of information about emissions. Importantly, it also does not reach the new source performance standards. As many of you may know, EPA is currently has, I guess, at the White House, a rule that would set greenhouse gas emission standards for new and modified power plants, as we understand it, and has committed more or less in a settlement agreement to develop NSPS standards for greenhouse gases, not only for new power plants, but also existing power plants, and also for new and existing refineries. All this authority comes under Section 111 of the Clean Air Act, and if the decision in this case is confined to an interpretation of the PSD provisions, it does not affect EPA's authority to regulate under the NSPS. What would that mean? Well, if the concern here is just, if this decision just addresses and in some way invalidates or leads EPA to avoid PSD permitting for greenhouse gases, There are some arguments, I think, that this may end up being a better climate policy for the EPA, insofar as the PSD program involves this sort of case-by-case, permit-by-permit determinations of what is best available control technology for this facility, and a cumbersome and maybe, I'll offer an opinion, not very well suited to greenhouse gases. If that gives way and EPA is left with regulation under the new source performance standards, where it sets across-the-board standards for facilities of a particular type, and would do that for power plants, would do that for refineries. Again, there will be legal challenges, no doubt, to those regulations, but I would submit it could be a more rational form of regulation than if it was than PSD-based regulation of greenhouse gases, and I think probably would not be affected by this decision. And there is at least some question. Some people have noted, for instance, that regulation under the new source performance standards, that EPA may have authority in that area even to do market-based approaches. Again, all these I think will be legally tested if EPA goes forward in this area. But again, those authorities, however they're ultimately defined, would not be affected by this sort of decision if it was limited to an interpretation of the PSD provisions in the Clean Air Act. I think another interesting implication of this particular form of decision, and I'm speaking in one form. Allison actually, I think, correctly laid out it could take a number of forms, but I'm sort of grouping them together as something that affects Section 169. If the upshot of that decision is, okay, well, there's no authority under Section 169 to regulate emissions not subject to national ambient air quality standards, well, that may not be the end of the story. There is a petition for rulemaking out there, the sort of petition that led to the tailpipe rule, a petition for rulemaking out there that says to EPA, you know, in your endangerment finding, you've done the sort of finding that also triggers a national ambient air quality standard. The language is similar. This is a different part of the Clean Air Act. So you should set, you are mandated, you have a non-discretionary duty to establish national ambient air quality standards for greenhouse gases, which would presumably put everybody back in the soup on this PSD permitting issue. Now, there are a number of people up here who have experience with the NAAQS. I expect that would be a multi-year process to develop national ambient air quality